This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Mr. Clerk, and welcome everyone to the call of the Tennessee Court of Criminal Appeals docket in Jackson, Tennessee for November. This is our final afternoon of oral arguments that we have scheduled. We want to remind you that oral arguments on Zoom are run by the same rules that we work when we're in person, and that is each side is given 20 minutes. If you wish any rebuttal time, please announce it upon introducing yourself to the court. We have a panel today that consists of representations from the entire state. Judge Easter from Middle Tennessee and Franklin, Judge Norman McGee Ogle from Sevierville in East Tennessee. I'm from West Tennessee. I'm John Everett Williams. With that, Mr. Clerk, would you call the first afternoon case?
State of Tennessee versus Corey Allen Harris.
You may proceed, ma'am.
Thank you, Your Honor. Good afternoon. May it please the court. My name is Jessica Butler with the Appellate Division of the Public Defenders Conference on behalf of the appellant, Mr. Corey Harris. Your Honor, if I could reserve 3 minutes for rebuttal.
Yes, ma'am, and I'll help you keep up with that. Thank you.
Thank you, Your Honor. Mr. Harris was charged with 1 count of attempted first-degree murder, 1 count of aggravated assault, and employing a firearm during the commission of a dangerous felony. These charges stem from an encounter between Mr. Harris and the victim, in this case, Mr. Chapman, outside the latter's place of employment one evening. Mr. Harris was there to encounter Mr. Chapman based on allegations that he had assaulted an ex-girlfriend who happened to also be a female friend and co-worker of Mr. Harris. It is undisputed by the parties that Mr. Harris discharged his firearm twice towards Mr. Chapman, grazing him on his back and causing what the medical proof referred to as an abrasion of the skin. So the only question for the jury in this case really was a question of intent. What was Mr. Harris's mens rea at the time that he discharged his weapon? So the jury acquitted Mr. Harris of attempted first-degree murder, but found him guilty of the lesser offense of attempted second-degree murder. And today we're challenging the sufficiency of the evidence regarding specifically the intent element of attempted second-degree murder. But really, to discuss sufficiency, I think you also have to address the jury instructions. And that was the second issue that I raised in my brief. So I'll actually start there and come back to sufficiency. The jury in this case, with regards to the attempted second-degree murder instruction, should have been instructed that in order to convict, it had to find that Mr. Harris acted with an intent to cause death, cause the knowing killing of another, and that he believed his conduct would cause that result without any further action on his part. Instead, what we have is a situation where the jury instructed the trial court instructed the jury that in order to find Mr. Harris guilty of this offense, it only needed to find that he unlawfully attempted to kill Mr. Chapman and that he acted knowingly, which is, of course, a general intent, whereas criminal attempt requires specific intent, intentional conduct. So as I said, Mr. Harris was initially charged with attempted first-degree murder, but the jury also was instructed on attempted second-degree murder as well as attempted voluntary manslaughter. At each juncture, as the trial court was explaining the elements to the jury, the trial court failed to define attempt for the jury. Now, in the case of the attempted first-degree murder instruction, I think it's still error, but not fatal error, because the instruction still included that element of intentional conduct. The jury was very clear about the fact that in order to find Mr. Harris guilty of attempted first-degree murder, it would have to find that he acted intentionally, intending to cause Mr. Chapman's death. What we have here is with the attempted second-degree instruction, the jury was given a lower mens rea to consider, just if you read the instruction on its face. That essentially, instead of finding that Mr. Harris acted intentionally, intended to cause Mr. Chapman's death, the jury could actually convict him of attempted second-degree murder if it found that he acted knowingly. And I will note that this was not objected to at the trial court level, so we are under plain error analysis in this situation. And the state has listed several cases in its brief, essentially arguing that attempt is a term of common usage that is so widely understood by the general public that it's really unnecessary to have that instruction included in the jury instructions. And so there's a couple of things that I want to touch on with regards to that point. One, if your honors look at the criminal attempt statute in the code, that statute includes 3 subsections that define different portions of attempt. There are essentially 3 different ways that an individual can attempt an offense, depending on what the offense is, as it's outlined in the statute. Relatedly, the pattern jury instructions include, again, those same, varying degrees of those subsections, potentially even a 4th subsection, depending on what the offense is. All that to say that this is clearly not a rudimentary issue. It's not something that trial courts pass off lightly. There are definitely instances, I cited one in my brief, where trial courts commit an error by failing to instruct the jury on the proper subsection. And this court has said that that is actually error, not necessarily plain error, not necessarily a fatal error, but that is in fact error. So the idea that trial courts struggle with this, that there are times that trial courts will incorrectly instruct on the improper subsection of attempt. Law school students, obviously that's the basis of any 1L criminal law class, is understanding the nuances of attempt. So the notion that all of these different entities and individuals might struggle with that concept, but that the general public would have no problems understanding what attempt means without any type of instruction from the trial court, I don't think that meshes with the way that the statute is outlined, given the complexities of it and within each of those subsections. And additionally, I think if you follow the state's argument kind of to its natural conclusion, the same could potentially be said for any number of offenses in the criminal code. That, okay, if juries naturally understand attempt without any instruction from the trial court, certainly they would also understand, say, murder or robbery or any other offense that's in the criminal code. But that really flies in the face of why we have jury instructions in the first place. The fact is that the legal definition of many of these offenses, the legal elements of these offenses, differ widely from the general public's understanding. Not to mention, 12 members of the general public could have 12 different interpretations of what the elements of a given offense are without adequate instruction. So even under the plain error analysis, there is a substantial injustice here, particularly because of the difference in the mens rea. So if this were a situation where the jury was adequately informed that it still had to find some element of intentional conduct, then I think we'd be in a different situation. And certainly I think that's the case in the 2 cases that the state cited from this court from several years prior. That in each of those cases, this was really a collateral issue. It was really inconsequential to the broader issues in the case. With respect to the federal case that the state cited from the 11th Circuit, that opinion is 55 pages long, and the discussion regarding attempt encompasses maybe a paragraph. So obviously it was really inconsequential to the broader issues in the case. This would really be the first time, at least that I could find, that this court would be engaging with this issue on the merits under a plain error analysis. And again, I understand that there is obviously a heightened burden that we are faced with under plain error analysis. But because of the difference in the mens rea, there's a substantial injustice there. Essentially, what happened here, if you read the jury instructions, is that the jury was allowed to convict Mr. Harris of attempted second-degree murder if it found that he acted knowingly. That is not the standard of proof. That's not the state's burden to prove at trial. The state had to prove that Mr. Harris acted with an intent to cause death. That was, from the very beginning, the central issue of this case, and that is the exact issue that the trial court failed to adequately instruct the jury on. And in essence, what that did was it lowered the state's burden of proof, and therein lies a substantial injustice, that the state was allowed to secure a conviction without proving each and every element of the offense. And to some extent, I think that relates back to sufficiency, which is a bit of an easier standard for us to cover. With regards to the sufficiency of the evidence, again, the state was required to secure a conviction based on every element of the offense. What happened here, as far as we can presume, is that the state secured a conviction without proving intent. It proved knowing conduct, not intentional conduct. And so as a matter of law, the jury's verdict cannot stand because it is based on erroneous law. The jury's verdict is based on its assumption that Mr. Harris acted knowingly, not intentionally. But that's not the standard that the jury was supposed to be looking at. That's not the standard that the jury was supposed to be given. And so if you look at it, I think that the evidence that was presented at trial, again, that was the central issue, intent. I don't think that the state proved intent, nor can we assume that the jury inferred that intent, because it was not instructed. And we can't go back and we can't poll the jury and ask them, well, did you think that he acted knowingly or intentionally? All we have is what's on the record and what the instruction that the trial court gave to the jury. And in that instance, we have an instruction that says knowingly and nothing else. And so as a matter of law, the jury's verdict cannot stand because it's built on an analysis that's incorrect. I do want to note that in the two cases that the state points out as far as plain error analysis, in one of those cases, as I said, this was really a collateral issue. It was a situation where the defendant was charged with felony murder and perpetration or attempted perpetration of a rape. Again, that was really collateral to the broader issue. The question about whether or not he intended to commit rape or actually went through with the completed act was not central to that discussion. And there was also some testimony there about the fact that he had actually admitted to completing that act. So in that situation, I think we had a situation where the proof was overwhelming to the point that the court didn't really need to engage with the issue on the merits. Likewise, in the other case, the court essentially said that the evidence was so overwhelming in that case that, again, it did not need to engage with this specific question on the merits under the plain error analysis. That is not the case that we have here. This was a very close case with regards to the proof regarding intent specifically. As I said, the victim's injuries were fairly minor. He suffered an abrasion to the back. He was returning to work just a few weeks later. Very limited amount of time in the hospital. There was definitely no discussion between Mr. Harris or Mr. Chapman where Mr. Harris gave any kind of intent to cause anything more than, as he said, to threaten him. Mr. Harris gave a statement to the police saying that he did this to scare him, that there was no intent to cause death. So with such a close jury question already, I think that's compounded by the fact that the jury was given the incorrect instruction on top of that. And it's really difficult to conceive a situation where the jury could have looked at the evidence that they were given and come to the realization that Mr. Harris attempted second-degree murder, especially with that lower mens rea that they were given in that case. So if the court has no further questions, I will turn it over to the state and
Ms. Butler, I do have a question. I want to make sure I
Yes, Your
understand the
Honor.
argument. I want to make sure I understand what you're saying. Did the court instruct the jury on the legal definition of intentional? Did the court give that instruction?
It did. So the way that the jury instruction is read out, with regards to the attempted first-degree murder instruction, the court did say that it had to prove that he acted intentionally and with premeditation, and it defined intentionally. With the attempted second, I'm sorry, Your Honor. Go ahead.
Is it your position though that that the court would have had to told the jury that before they could convict him of attempt, the state would have to prove that he intentionally attempted to commit whatever offense they find him guilty of? Is that what you're
Well,
saying?
not quite, Your Honor. I think obviously attempt in the legal context necessarily includes that element of intent. The problem with the second degree murder instruction is that it says that the jury could find that he committed attempted second degree murder if they found that he acted knowingly. Then there's a drop down, and the trial court says that it could also find it if they found that he acted intentionally. But the presumptive question at the top is that he acted knowingly. So yes, it does explain if you find that he acted knowingly or intentionally, you could find that he committed attempted second degree murder. But because it led with the knowingly standard and didn't make it clear that the knowingly standard is not the standard that it was required to prove, therein lies the issue, because we have a situation where potentially, and I think presumably, the jury understood that it could convict on attempted second degree murder if it found that he didn't act intentionally, but also there was no adequate provocation to encompass attempted voluntary manslaughter. Therein lies the issue, is that yes, the intentional language was included, but it was essentially an aside to the initial instruction that it could find that he acted knowingly.
Thank you.
Thank you.
Thank you, Ms. Butler. General, you ready?
I am. May it please the court, Jim Gaylord on behalf of the state. Well, this is a shoot and miss case. And on the jury instruction issue, there are two impediments to plain error review. The first is that the notion of attempt is a word in common usage, and the jury surely knows what it meant. The second is that the jury was correctly instructed and found the mens rea of the underlying offense of second degree murder. The first of these means that no substantial right was affected. The second of these means there is no need to do substantial justice. So in the shoot and miss case, what the defendant's desire here is that the jury would have been instructed that attempt means that there had to be intent to cause an element of the underlying offense. And the difficulty with predicating plain error on that contention is that the notion of intent is inherent in the ordinary meaning of attempt. To speak plainly, when we say attempt to do something, we mean try to accomplish that, to try to do something. Well, if you are trying to do something, that something is your conscious objective. And that is the legal definition of attempt. And the jury in this case surely knew the score. I mean, the state's theory is that the defendant acted with intent to kill, and in fact that he acted with premeditation. The defendant's theory offered through a police statement that offered through a statement that he made to police was that he was firing at the ground and he was just trying to scare the victim. The jury said, well, we don't find enough proof for there to be premeditation, but we do think that he was trying to kill or attempting to kill. And it's hard to imagine how the jury could have been confused about this notion of intent. So because here in this context, it's a word in common usage, no substantial right is adversely affected. And it is true that there are two other prongs to the attempt statute, and there might be cases under those other prongs where an instruction really should be given. I mean, if we're talking about a substantial step case, and maybe if it's a bank robbery where no actual demand for money is made, the jury probably does need to get an instruction that the step has to be substantial, and the course of conduct all has to corroborate the intent. But in a shoot and miss case, when we're just talking about, was he trying to kill, was he trying to scare, the jury understands that. And I don't think that even under plenary review, that this would be harmful. The second difficulty with plain error in this case is that the jury was instructed that the defendant had to act knowingly, and the jury found that he acted knowingly. So what that means is that the jury found that by engaging in this conduct, by pulling the trigger, he was aware that it was reasonably certain to cause the victim's death. So the question becomes, in this case, how could the jury have thought that the defendant was aware that by pulling the trigger, he was reasonably certain that he was going to cause death, but not have the conscious objective of causing that death? It is not an easy question to answer. I don't think it is possible to answer that question on the facts of this case. And again, the jury was just deciding whether to accept the defendant's tale that he was trying to scare the victim. And further instructions on the nuances of the second prong of the attempt statute just weren't going to make a difference in this case. So I don't think the defendant can satisfy two of the prongs of the plain error test in this case. And with that done, sufficiency is not a substantial question in this case. It is undisputed that the defendant fired 2 shots at the victim and hit him once in the back. The jury could find attempt to kill from that conduct alone, and there is more. There's evidence of motive. It's undisputed that he went to the victim's place of employment armed with a gun. There's evidence that he concealed himself. There's evidence of pursuit. It's undisputed that he fled, and it is undisputed that he disposed of the murder weapon. On all of that evidence, this is not a close case, and certainly the court should not find that that the evidence is insufficient. If there are no questions, we would ask that you affirm the judgment.
Ms. Butler, you have your rebuttal.
Thank you, Your Honor. So first I'll just address the state's argument that there are instances where an attempt instruction is necessary. Yet in the brief and here at oral argument, the state's also arguing that this is such a commonly understood concept that there's no need to instruct the jury. So it seems like the state is really trying to have it both ways. Either this is a concept that is complex for the general public and needs to be properly instructed, or it's something that's so commonly understood that we could almost do away with it entirely. I think it's clear, and the state is really saying as much, that because there are instances where this is a very complicated issue for jurors, it's necessary to instruct the jury fully on each of these issues. Again, here especially, because the way that the instruction is written lowers the state's burden of proof. The intent question was the only question for the jury to decide here. If they're not properly informed as to what intentional conduct in the context of attempted second-degree murder looks like, we cannot make all the inferences that the state is making in its argument that the jury understood what this meant, did it, out of a clear understanding of what the elements were. The state's making a lot of inferences that are not necessarily supported by the record simply because we don't know, and we do not know because the instruction was incorrect. And I know that the state is arguing that essentially it was correct. I think it's very clear if your honors look at the instruction that it's not. Obviously, the instruction doesn't have to follow the pattern jury instructions to the letter, but it does have to encompass all of the elements. And that's not the case here. It's very clear from reading the attempted second-degree murder instruction that the trial court simply left out the instruction to the jury that it had to find that Mr. Harris acted intentionally and nothing less. The instruction as written, as read by the jury, as received by the jury, clearly states that it could find that Mr. Harris attempted second-degree murder if he acted knowingly. That's not the case. And I think in some ways, I think jurors may understand attempt in the murder context, not necessarily to include this inherent idea of intent, but simply that the victim lived, and therein lies the attempt. That's what separates an attempted murder from a completed murder, is that the victim didn't die. Not that it necessarily encompasses this intentional discussion, this intentional conduct, that it absolutely does necessitate in the legal context. So with that, we'll rest. There is a third issue that was briefed. I don't have time to get into it, so I'll rest on the briefs with regards to the prosecutorial misconduct argument. But we would ask the court to vacate Mr. Harris's conviction for attempted second-degree murder due to a lack of sufficient evidence regarding intent, or in the alternative, to reverse and remand for a new trial based on the plain error of failing to instruct the jury as to the definition of attempt. Thank you.
Thank both of you. I was remiss earlier today in not thanking the Judge Clerk Hivner's staff, the AOC staff, your staffs, and whatever hurdles you had to jump through to help us accommodate a change in schedule this week and allow us to be here on Zoom this afternoon. We appreciate all the help that everyone gives behind the scenes, and the attorneys have been marvelous over the last year in helping us continue this process. We are very, very happy and look forward to returning to the courtroom in person in January. And we hope that target date can be kept and continue there for many years thereafter. But thank y'all for helping us reschedule for this special session today. And with that, we'll stand adjourned to let the call of the next case at 2:00.
The Honorable Court is now in recess until 2 p.m.